Hello, YouTube. I'm Vince White. I'm an employment attorney. On this channel, we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. It is Christmas morning. I hope you are having a happy, healthy, and also wealthy Christmas day. I hope everything's really good. Although, odds are, if you're watching this channel, perhaps they're not. Perhaps you're worried about an employment issue, and that stinks. But don't worry. I wore my gingerbread person onesie, my gingerbread man onesie, to cheer you up. So fast as fast can be, you'll never catch me. We have a question here from J Segura 525 who asks us, is it better to wait until the EEOC has completed their investigation before you ask for the right to sue letter? Excuse me. Can you ask the EEOC to end their investigation and issue you the right to sue letter? Which seems like the better choice? Well, let's start with what you can do. So you can ask the EEOC generally to end their investigation early and give you a right to sue letter. Now, that goes much better, I think, when you're represented. I don't know for a fact that they'll do that for you when you're unrepresented because they've never done it as an unrepresented person. But I suspect they might often still give you the right to sue letter. If you say, listen, you don't have to do your job. You don't have to investigate. Just give me a right to sue letter and we can all be done here. And I'll go on to federal court. So I know you can do that as an attorney. I suspect you can do that as a pro se litigant in the EEOC. You can do that. That is an option. Now, the question about which path you want to go down is a different story. It's going to be it's going to be tied to what you're looking for. So a lot of times I will leave a case in the EEOC to get some free discovery or to grind defense attorneys, grind defense costs, right? There's a lot of the EEOC spends a little bit of time and effort, and there are certain cases in which you want to use that little bit of time and effort the EEOC will create to hopefully multiply the time and effort spent by defense counsel, or to get certain things, or to keep a case quiet, right? Like if you're looking to quiet case, you cannot do that if you bump your case onto federal litigation. It's very unlikely you'll be able to keep your case quiet on a federal docket. A federal docket for federal litigation is a public docket. You can tell because you can just go to Pacer and start pulling documents off the federal docket, right? Like everything you file is going to be, not everything, most of what you file during your federal litigation will be available publicly on a variety of different like websites and Pacer and everything else. Now, and people can also just go into ECF and start pulling things out. Like there's a lot that can go on. It's not a good way to keep things quiet. So if you're looking at a quiet case, certainly you'd want to probably keep your case at the EEOC level for as long as you can while you see if it settles or not. That's another reason why you might want to keep the EEOC process going, the investigation going. Now, why would you want to pull the right to sue letter early? A couple of reasons. One, maximum aggression. Like that would be potentially beneficial for you. There are also, in the same way there's cases that I would leave lingering in the EEOC, there are cases where I'm like, no, we need to be like the Mongolian hordes here. And I don't like referencing the Nazis, but the Blitz. You need to really have this like incredibly aggressive, fast attack style of litigation. So you like send your letter. Maybe you have a negotiation, maybe you don't. You file with the EEOC. You file your EEOC filing with a pull letter, being like, hey, guess what, guys? You men and women of the EEOC, you don't have to actually do anything. You can just issue my right to sue letter. We want Fed lit. We want federal litigation. And that aggression can cause a lot of angst, a lot of turmoil on the defendant's side. They can be scrambling to find the right counsel for federal litigation. They can be scrambling to get evidence together. There can be a lot of reasons why you would do that, and it's a tactic we often employ. Now, there's additional reasons why you might not want to let your case linger, even if you're not going for the like blitz style of litigation. Witnesses forget things, documents get lost. Witnesses die. Witnesses move away. Witnesses move to other states and become hard to obtain. Time can slowly erode some of your evidence, and I don't love that for any of us. Also, listen, you can want a case to move faster because you don't want your defendants to grow comfortable. There's definitely defendants who I've like watched grow comfortable with liability. Like, yeah, so we're gonna probably pay that guy $500,000 sometime, but like not right now, and they get comfortable with it, and that's not what we're trying to do here. We're not trying to create any level of comfort in our opponents, right? I mean, we're hitting people happy hour, the commute home Friday evening when they think they're safe from work. We're hitting them with our demand letters, right? Like the part of the goal is create the most tension you can in your opponent because your case can hurt them emotionally, and that makes it something they want to get taken care of, right? The squeaky wheel gets the oil. So, if you're constantly causing havoc and you're constantly on their minds and you're constantly harshing their mellow, it is much more likely that they will be like, we got to get this done. What does this person want? Just give them what they want, right? Like that's an emotion you're looking to engender in your opponents in this field. So don't forget that. What else can I tell you? It is a nuanced and detail-driven choice as to whether or not you let your EEOC case run its course or you pull your right to sue letter and proceed on to federal litigation. There's also different employers. There's employers who just want to purchase silence. They don't really care about the dollars. This was like I would point to some of the big tech companies before California rolled out its recent laws that make confidentiality a little bit more difficult to achieve in settlement agreements. There's a lot of big tech companies who'd be like, well, okay, as long as the case is quiet, we'll pay a settlement to keep it that way. So like the EEOC, where the case is quiet and the case is not like out on a public docket, they're like really motivated to pay money, right? But if you escalate the case, excuse me, if you escalate the case and it's in the public eye, they're like, well, we don't care anymore. We have more money than God, and you already hurt our public persona, our brand, so we don't care anymore about that. So no settlement. We'll see you in court, right? Like there's those cases. There's also cases. Not all big tech is created the equal. IBM had at one point so many cases against it. They had to hire their own attorneys, like in-house. They had to form legal departments to deal with all of the cases against IBM. I assure you, they were not like, oh no, not another case in the public eye. Like, I think they settled like 400 cases at once in Britain at one point. Like they had so many cases going that like additional cases just didn't matter to them at all. And there's all certain defense attorneys are going to say different things to you, right? Which is why Mr. J. Segura 525, I'm going to always recommend you're represented, because the representation, you're going to learn things from your attorney. Like, this defense counsel needs to bill a little bit. This defense counsel needs to make her or his bonus for the year. They're going to need an extra 50 hours on this case. So we're going to have to get them to that billing point before they're going to cut you a check. And it's not like the defense counsel says that outright, but like you're having a conversation with defense counsel, you're like, oh God, I'm behind on my hours this year. I'm not going to make max bonus for my big law job. And my third mistress is really giving me a hard time about not buying her a Ford Bronco, because she's the third mistress. She's not going to get the Mercedes. I mean, come on. I don't know. I love this persona that I create for big law attorneys, where they're all like divorced 5 times with like 5 mistresses or 5 affairs going on. They're not all like that, I assure you. Some of them are really, their lives are going well. They're happy, healthy. It's great. But there's like a little there's a few folks on the defense side who like live up to the persona that I create or inspire the persona that I create for defense counsel. Like it's not like I'm thinking of certain human beings and I'm like giving you the story about like I'm 50 hours behind on my max bonus and my third mistress is getting salty. Like that person exists. And those conversations happen. They're not saying I need to build this case for 50 hours before I'll give you money. That would be unethical. They can't say that. But they can sure tell you they need 50 hours. Or else bad things are going to happen to them. And you're like, okay, I will get you the biggest. Like, I will amend my complaint in the EEOC to mess with you 3 times. You're going to be doing 3 position statements. And then I think my rebuttal is going to crush you so hard you're going to have to draft some more stuff, even though you don't really have the right to. You're going to draft it anyways because you're going to be like, well, the EEOC's got to hear this. And if that's what you got to do to get defense counsel to cut a check for your client, then that's what you got to do. Defense counsel's ethical issues are not my ethical issues. Defense counsel wants to overbill her or his client. I'm going to watch and I'm going to say, that's unfortunate for everyone involved, but not my problem. My problem is this check for my client or get this case on to trial one way or the other, right? As per my client's wishes. So, Jay Segura, I hope this was a 12-minute way of answering your question, and I wish you great luck with your decision and with your case. If this video was helpful, like, subscribe, and comment down below. It helps me to help more people just like you. Let's keep the channel growing, and I will track this video for follow-up questions if there's anything further I can answer for you. Take care.